Welcome to our collection of videos showing different aspects of quantity surveying. My name is Kylie Rowland. These videos are based on New Zealand and Australian legislation, but are similar and all the same worldwide. Please check your local authorities for guidance and confirmation. Today's video is on contracts. Contracts in construction form the backbone of a project, defining the rights, responsibilities, and obligations of all parties involved. Contracts are essential for ensuring that both the client and the contractor have a clear understanding of project expectations, timelines, costs, and quality standards throughout the project's life cycle. Key aspects that are typically covered include scope of works, payment terms, project timeline, liability, and risk. Having a solid agreement in place is key to the success of a construction project. Standard forms like the NZS 3910, NZS 3915 are commonly used in both private and public sector projects. The most common types of contracts include the lump sum contracts. Under a lump sum contract, the contractor agrees to complete the work for a fixed price. This type of contract is commonly used in smaller or well-defined projects where the scope of work is clear and unlikely to change. The contractor takes on the risk of cost overruns, but benefits if they complete the work under budget. Cost plus contracts. In this arrangement, the contractor is reimbursed for the actual cost of labour, materials, and other project expenses, plus a predetermined fee or percentage for profit. This contract type is suitable for projects with uncertain scopes or where changes are expected during construction. The client takes on more risk regarding cost escalation, but the contractor has an incentive to control costs effectively. Design and build contracts. This contract type combines both design and construction into a single agreement, with a contractor responsible for both. It is often used in projects where time and cost efficiency are prioritised, as it streamlines the design and construction phases. The contractor is fully responsible for delivering the project, including obtaining consents and ensuring that the design meets the client's specifications. Construction management contracts. This type of contract is where a construction manager is engaged to oversee the construction process on behalf of the client. The construction manager does not take on direct responsibility for the work, but manages contractors on behalf of the client. It is useful in large or complex projects where the client prefers a more hands-on management approach. Lastly, fixed price contracts. In this contract, the contractor agrees to complete the project at a fixed price, with little or no flexibility for changes in scope or price. It is often used when the project is straightforward and predictable. The contractor assumes the risk of cost overruns but has the opportunity for higher profits if the project is completed under budget. Contractors and clients in New Zealand must carefully consider the most appropriate contract type to suit their specific needs and project parameters. Key terms and clauses in New Zealand contracts. The New Zealand construction contracts contain several key clauses and terms that help to define the responsibility of all parties involved. Scope of works. This clause clearly defines the work to be carried out by the contractor, including any specific deliverables, quality standards, and timelines. It is critical to ensure that both parties understand and agree on the expected outcomes. Payment terms. Payment clauses outline the frequency of payments, payment milestones, and any conditions for payment. In New Zealand, payments are often made according to the progress of the work, with periodic claims for completed work. The Construction Contracts Act 2002 governs these payment provisions, ensuring that contractors are paid promptly for work done. Time and completion. This clause specifies when the work is to be completed, the timeframes for different project stages, and the conditions under which extensions of time may be granted. Penalties or liquidated damages may also be specified in the case of delays caused by the contractor. Variation clauses. Variation clauses outline how changes to the scope of work will be handled. It includes the procedures for issuing and pricing variations and whether or not these changes affect the overall contract price or project timeline. It includes the procedures for issuing and pricing variations and whether or not these changes affect the overall contract price or project timeline. Risk allocation. This clause sets out which party bears the risk for specific circumstances. For example, it might clarify that the contractor is responsible for on-site safety, while the client is responsible for site conditions or unforeseen delays. This helps prevent disputes over who is liable for damages or losses during construction. Dispute resolution. New Zealand construction contracts often include a dispute resolution clause that outlines the steps to take in case of a disagreement between the parties. This may include negotiation, mediation, arbitration, or litigation. The goal is to provide an efficient mechanism for resolving issues without resorting to costly litigation. Insurance and bonds. This clause outlines the types of insurance required for both parties, such as public liability insurance, workers' compensation, and performance bonds. It ensures that both the client and contractor are protected for unforeseen events that could affect the project. The legal framework, including common law, statutory regulations, and industry-specific legislation, is described in our construction law video. Understanding these regulations is essential for both contractors and clients in New Zealand, as non-compliance can lead to legal issues, delays, or even fines. Legal advice should be sought when drafting or signing a construction contract to ensure compliance with all applicable laws. Dispute resolution. Dispute resolution in New Zealand construction contracts. Despite best efforts, disputes can arise during construction projects. New Zealand construction contracts typically include provision for resolving these disputes in a fair and efficient manner. The main methods of dispute resolution include negotiation. The first step in any dispute is typically negotiation between the parties. Open, clear communication can often resolve minor issues before they escalate into formal disputes. In many cases, issues can be resolved through meetings, emails, or phone calls. Mediation. If negotiation fails, mediation is often the next step. A neutral third party, the mediator, facilitates discussions between the parties to help them reach a mutual agreement solution. Mediation is generally less formal and less expensive than litigation, making it a popular choice for resolving construction disputes. Adjudication. Under the Construction Contracts Act 2002, adjudication is a fast-track process for resolving disputes related to payment claims. The process allows parties to get a binding decision from an independent adjudicator quickly, without the need for lengthy court proceedings. It is often used when there are disputes over progress payments, variations, and other contract-related issues. Arbitration. Arbitration is a widely used method of alternative dispute resolution in construction projects, where an impartial third party, known as the arbitrator, is appointed to review the evidence, hear the arguments from all involved, and make a binding decision to resolve the dispute. Unlike court proceedings, arbitration is typically faster, more flexible, and confidential, offering a streamlined process to settle conflicts without the need for litigation. It is often preferred for resolving issues related to contract terms, delays, and payment disputes, providing a more cost-effective and efficient way to bring closure to disagreements. In conclusion, construction contracts are fundamental to the successful management and completion of a project. providing a structured framework defining the rights, responsibilities and obligations of all parties. A construction contract typically covers aspects such as scope of works, payment terms, risk allocation, and dispute resolution. In an industry prone to complexity and change, a solid construction contract serves as a protective tool, ensuring that all obligations are met and that the project progresses smoothly from start to finish. Thank you for watching our videos. Please like, comment and subscribe to stay tuned in for more videos on quantity surveying. And please don't forget to subscribe to our Patreon channel for more in-depth videos on quantity surveying.